Hi guys, welcome to Legal Brilliance. Today we are going to discuss the concept of industry under Industrial Dispute Act 1947. Let's begin with the introduction. The main object of this act is to investigate and settle the industrial disputes that arise in the industries. This act is applicable to all establishments which come under the definition of industry given under Section 2J of the Act. Concept of industry. Section 2J of this Act defines industry as any business, trade, undertaking, manufacture, or calling of the employers and includes any calling, service, employment, handicraft, or industrial occupation or avocation of workmen. So this is the definition that is given under section 2J. But in simple term, if we want to understand what does it mean, it simply means a systematic and organized cooperation between employee and his employer. The purpose of such cooperation is for the purpose of production, supply, or distribution of goods and services. Now we will discuss the landmark judgment of Bangalore Water Supply versus A. Rajappa case, which is famously known as Bangalore Water Supply case. In this case, the Supreme Court has laid down guiding principles to determine whether an establishment is an industry or not. Following are the principles laid down by the court. First principle is triple test. For an enterprise to be called as an industry, it must fulfill following three conditions. The first condition is an establishment must have a systematic activity which is organized by cooperation between employer and employees, and this cooperation is for the production or distribution of goods and services to satisfy human wants and wishes. So these are the three conditions, and if any industry fulfills these three conditions, it will conform the triple test and it will be called as an industry. The second principle is any establishment which provides spiritual or religious services will not be considered as industry. Example, any establishment which is making on a large scale prasad or food will not be considered as an industry. Third principle, absence of profit motive or gainful object is irrelevant. It is a usual presumption is that an industry means a profit making organization. For the purpose of section 2J, it need not be an establishment need not have a profit motive. Even if it does not have a profit motive, it will still be considered as industry. In other words, it is immaterial whether or not there is a profit motive. Fourth principle, functional and decisive test to determine whether or not a particular establishment is an industry is the nature of the activity that is held by the establishment. If it shows special emphasis on employee-employer relationship, then it will be considered as an industry. Fifth condition is if the organization is a trade or business, it does not cease to be one because of philanthropy animating the undertaking. Simple terms, if any organization which is a trade or business, it does not stop to be a trade or business merely because it is run by charity. Example, a charitable hospital run by a private trust which offers free service and also employs the employee. It will still be considered as industry because it is providing free services and also it has emphasis on employee-employer relationship as per fourth principle. Sixth principle, all the departments which is integrated with industry will become an industry. The exception to these principles are if any industry functions, if any industrial functions are the sovereign functions of the government, then it will be exempted from the definition of industry. Example, if any industry which is run by the government and where the government has the full authority to run certain industry, for example maintenance of arms and ammunition, here the court has no say on it, and even the has no government has no authority to answer the court, because these functions are the sole functions of the government and it need not answer the court as to its functions, and hence these industries which is run by the sovereign function of the government are exempted. The following establishments by applying the triple test have been ruled as industries. First one, municipal corporations. In D.N. Banerjee versus P.R. Mukherjee case, which is famously known as Budge Municipality case, is a landmark judgment wherein two employees got dismissed for negligence, for which the industrial tribunal ruled that the employees must be reinstated or restored to their position as before. The municipality challenged this rule and contended that the municipality is not an industry and hence its employees cannot be treated as an industrial employee. The court observed that when public utility services such as water or electricity supply, railways, telephone, etc., when it is carried by private companies or business corporation is held to be industry, then why not such public utility services carried by local bodies like municipality can be held as industry? And thus, the Supreme Court held that municipality is an industry. Second one, hospitals. In the state of Bombay versus Hospital Mazdoor Sabha case, wherein Hospital Mazdoor Sabha is a registered trade union of employees of hospitals in the state of Bombay, of which two members were retrenched, that means permanently terminated from the service by the government. The union claimed reinstatement through writ petition, to which the state of Bombay, that is the government, contended that Hospital Mazdoor Sabha or the hospital is not an industry. In this case, Supreme Court laid down three conditions to determine whether a hospital falls within the definition of industry or not. Three conditions are: a government as well as charitable hospital which is run by private trust, and if it offers free services and employing a permanent staff is an industry. So even if a hospital is run by government or by charity, and if it is run by a private trust which provides free services and employing of permanent employee, it becomes an industry, because free service and employment are the two essential principles as we have discussed in Bangalore water supply case in the beginning. These are the two principles which is necessary to determine whether an industry is a industry or not. Then second condition is there is a systematic activity which is undertaken for the production or distribution of goods and services. Third condition is character of the activity must be similar to that of industry. Following three conditions were upheld in the case of Bangalore water supply versus A. Rajappa case, and it held that hospital facilities are surely service and hence it is industry. Third one, educational institutions. Bangalore water supply case overruled the judgment given under University of Delhi versus Ramnath and held that educational institutions are industries. Fourth one, clubs. In Madras Gymkhana Club Employees Union versus Management, the court held that the club does not fall within the definition of industry because it was a self serving institute. The same judgment was overruled in the case of Ratilal B versus Tata Sports, wherein the court held that the club satisfies the triple test formula and therefore it is an industry. Fifth one, solicitor's firm or lawyer's office. According to Bangalore water supply case, which overruled earlier decisions, held that solicitor's firm employs persons who help in the catering to the needs of the client, and hence it is an industry. Next, we will look into the position of other bodies, whether other establishment comes under the definition of industry. Other bodies such as cooperative society, chamber of commerce, partnership firm, bookshop, hair cutting salon, pharmacy, etc., are all held as industry, which fall within the meaning of industry under section 2J of the act. So these are following undertakings which fall within the definition of industry, and they fulfill the triple test as given under Bangalore water supply case. With this we come to the end of our discussion. Thank you.